Good morning, all. I am Seema, working in Dr. Drsnsrcas College of Arts and Science as an assistant professor in the Department of BCom CA. Today, I am going to present a topic on Companies Act 2013 and what all it's include. That is 470 sections and 7 schedules, 23 chapters, and the Act extends to the whole of India. So here I am going to give a brief description about the Companies Act, what all things are included in the Companies Act. So the Companies Amendment Bill was passed by the Lok Sabha. It introduced some changes in the Companies Act 2013 and it amends the laws related to Indian companies. In this article, you can read the salient features of the Companies Act 2013 and its comparison with the older Companies Act 1956. For the for aspirants, we can have a deep knowledge about the Companies Act 2013. And the Companies Act 2013 regulates the formation and functioning of corporations or companies in India. The first Companies Act after independence was passed in 1956, which governed business entities in the country. The 1956 Act was based on the recommendations of the Parpa Committee. This Act was amended multiple times and in 2013, major changes were introduced by Section 135 of the 2013 Act. India became the first country to make corporate social responsibility spending mandatory by law. And currently, the Ministry of Corporate Affairs is administering the following central government acts, that is Companies Act 2013, Companies Act 1956. Some provisions of the Companies Act only will apply, and Competition Act 2002, Insolvency and Bankruptcy Code 2016, and Chartered Accountants Act 1949. And we can have a main highlights on the Companies Act 2013. The maximum number of shareholders for a private company is 200 and previously it was 50. The concept of a one-person company has come after the Companies Act 2013 and the Company Law Appellate Tribunal and Company Law Tribunal and CSR was made mandatory. And we can see about the salient features of the Companies Act 2013. It was introduced the concept of dormant companies. Dormant companies are those that have not engaged in business for 2 years consecutively. That is called as dormant companies. And it introduced National Company Law Tribunal. It is a quasi-judicial body in India adjudicating issues concerning companies. It replaced the Company Law Board and it provides for self-regulation concerning disclosures and transparency rather than having a government approval based companies. Documents have to be maintained in electronic form. Official liquidators have adjudicatory powers for companies having net assets of up to rupees 1 crore. The procedure for mergers and amalgamations have been made faster and simpler. Cross-border mergers are allowed by this act, but with the permission of the Reserve Bank of India. The concept of a one-person company has been introduced. This is a new type of private company which may have only one director and one shareholder. That is known as one-person company. And the 1956 Act required at least two directors and two shareholders for a private company. Other than that, other than private company, one-person company is a company which is having only one director and one shareholder. And next thing is about having independent directors have made statutory requirement for public companies, and for a prescribed class of company, women directors are mandatory. All companies should have at least one director who has been a resident of India for not less than 182 days in the last calendar year. And the act provides for the entrenchment. Entrenchment means applying extra legal safeguards of the articles of association. The Act mandates at least 7 days of notice for calling board meetings. All this comes under the features of the Companies Act 2013, which contains 470 sections and 7 schedules, 23 chapters, and the Act extends to the whole of India. Thank you. Thank you very much.